Welcome once again to Lehto's Law. Here's Steve Lehto.
I do stories from time to time about attorneys getting in trouble. There's a lot of attorneys out there, something like 35,000 in Michigan, and attorneys in other states, of course. So several people sent me a story out of Connecticut about an attorney getting in trouble. Hamden attorney disbarred after empty and malicious claims. Ben Lambert wrote the story for the New Haven Register. A Hamden-based attorney was disbarred earlier this week after a judge found she had made empty and malicious claims, alleging that a judge was engaged in a Judaism-based conspiracy and was protecting child sexual abuse. Now, we've heard a lot of people talking about this kind of stuff, whether or not a judge is corrupt or on the take or something. But when attorneys are in court, they can't just say stuff. They have to have things to back up what they're saying, especially if they're representing somebody. And if you make a representation to the court, it's got to be factual based, and you have to have a good faith belief in it or some reason to be promoting it as true. So if you make a statement in court about something that's factual and you say, this is true, a judge has the right to stop you and say, excuse me, how would you show that or prove that or demonstrate that to the court? I'm curious about that. And you better have a basis for it. And I've seen attorneys go a little bit too far, and I've seen a judge call them on it, and I've seen them backpedal. Well, Your Honor, my client says they spoke to somebody who told them that, and the judge will stop them and say, do you know who the person is who made the statement, and can you get them in here to testify? Well, I'll ask my client, okay, until you ask your client and you can get the person in here, let's back up, and we're not going to talk about that, okay? Okay. So it's important that as an attorney, you know these kind of things. A judge filed a memorandum regarding his order to disbar the attorney earlier this week, saying she had engaged in grave misconduct while representing a Glastonbury woman engaged in a dissolution of marriage case. So it's a divorce case. And this attorney appears in front of the judge. And the attorney said in a statement Friday that she was being targeted for going public with the truth regarding the case, including the alleged mistreatment of her client and her client's children. During the course of the case, she alleged that a judge favored Jews in cases, noting that several officials involved in the court's inquiry were Jewish, as well as discriminated against the disabled, and in this matter was protecting child sexual abuse. And that's what the judge wrote in his memorandum. And again, you can make allegations, but you need to have stuff to back it up. You can't just make allegations. So the attorney had alleged that she has evidence, including a list of cases in which the judge had inappropriately favored Jewish people, but when asked at a hearing, failed to produce any such information and admitted she did not have such a list. So we've all heard the famous story about Senator McCarthy going, I've got a list right here, and this is a list of all the names of people who are in the Communist Party in this organization, the Senate, or in the Congress, or in Hollywood. He kept claiming he had lists. He's going to show the list. Never showed the list to anybody. There really was no list. It was just a piece of paper. It looked like a list, right? So this attorney told the court, I've got a list of cases that backs us up. Judge said, let's see the list. Oh, I don't have a list. Oh, okay. So you have no list. So the previous statement you made was false. You made a false statement to the court, and the court, the statement that you made was rather inflammatory. And that is a problem. So when she was asked at a hearing to produce it, she failed to produce any such information and admitted she did not have such a list. So the judge wrote, this is a matter about a lawyer. When lawyers speak, the public rightly assumes they don't speak lightly. After all, the truth is their business. Therefore, her lies about a Jewish conspiracy are particularly reprehensible. Without the court exposing them as lies, the public might give them some credit when they deserve none, said the judge, writing in the opinion. Misconduct like this threatens to drag the courts into the primordial ooze that passes for public discourse in some quarters today. One whiff of this swamp should be enough for the courts and those of its officers that are true to their duties to set out firmly in the other direction. This moment is one chance to do so. Now, the attorney also had alleged that a relative of her client had abused her client's children, arguing it was demonstrated in records from the State Department of Children and Families that a judge was ignoring, according to the memo. But the records in question found that claims of abuse had been investigated and determined to be unfounded. So the judge writing the opinion about the disbarment wrote, "It passes understanding why a person would wager so much on blatant falsehoods. The attorney was warned repeatedly of the seriousness of this matter and still chose to reassert and insist on things about the DCF records when she had every reason to know they were completely false." And so you might say, but Steve, what if those records were wrong? What if those records were wrong? And so here's the thing, and I know a lot of people, when they hear attorneys explain this kind of stuff, go, that's just splitting hairs, you're being nitpicky, that's why people don't like lawyers. Let's suppose that you were aware of allegations that somebody had abused somebody else. You heard there were allegations, okay? An agency stepped in and investigated those allegations. And then the agency came to the conclusion that there is no basis to the allegations at all. So if I'm going to go into court as an attorney and somehow I think that's relevant, if I say, Your Honor, there were allegations made of abuse, that's documented. There were allegations made. The judge has the right to say, what became of those allegations? Well, they were described as unfounded by the investigating agency and the charges were dismissed. Nothing ever happened with it. So if the attorney knows that, the attorney should also disclose that because that actually is the full picture. And it is wrong for an attorney to go into court and give one portion of a story and purposely leave out the other portion when they're talking to the court. Now, I don't know exactly how all of these transactions went down. I'm talking about a hypothetical situation. So if I went into court and say, Your Honor, that person abused the other person. Okay? One person abused the other person. There was abuse. The judge is probably going to ask and go, what do you base that on? Well, there was an allegation made. What became of the allegation? An investigation. What became of the investigation? They found nothing wrong and they dismissed it. So if you want to talk about what happened here, you really can't say it happened unless you have firsthand knowledge, in which case that's a different story altogether. But for you to simply say, well, there was abuse, and I know that for a fact because there's an investigation which found nothing, would be misleading to the court. So you could say there have been allegations of abuse and the allegations were investigated and dismissed, but my client feels strongly that was incorrect. You can do that, and that might be true. But you have to look at what's being said. But the idea that there's this vast conspiracy against your client among all these judges, the legal system, or whatever it is, and it's racially motivated, by the way, and you have all this, and you say, by the way, I've got evidence. I've got a list. I got a list. Don't ever tell somebody you have a list unless you can show it to them. Because a list sounds like something I want to see. I'd like to see that list. Show me your list. So when Senator McCarthy was in front of these different organizations and waving around, usually news cameras, waving around this list, the natural question that they asked him was, can we see the list? And he kept saying, no, I'll show it to you later. And he basically did that for as long as he could until it ran out of steam because people started to realize, wait, there must not be an actual list. And by the way, if I have a list that I made myself, how meaningful is it? Does it have any evidence on it? So that's what's even crazier, is that she said that she had a list of cases, but she also said she had evidence. And then when asked to see it, didn't produce a list and then admitted she did not have such a list. She could have made a list. It's not that hard to do, make a list of a bunch of cases. Go, that's the list of cases that I believed was incorrect. But apparently said, well, I don't have such a list. So it's a bizarre story, but she's been disbarred. And it sounds to me like their process might be a little different out there than it is here in Michigan. In Michigan, what happens is somebody files a complaint with the state bar and says this attorney has, committed some kind of misconduct, and then they review it and they decide if it's serious. And if it's serious, and they hold hearings, and then these hearings aren't held in the same courts that court cases are heard in. They're hearings being held by the state bar. And so And then in that case, if they come to a conclusion and make a ruling, then they turn it over to the state Supreme Court, and the state Supreme Court either agrees with it, says they don't agree with it, or modifies it. But one of those three things, and then they impose the sanctions. So here, it's just a judge who ordered this, and I'm not sure what led to it procedurally, but apparently one of the biggest problems here was she said, apparently in open court, I have this list, and it proves something. And when asked to produce the list, she said, there is no list. And I've mentioned before that attorneys, when they go into court, are not sworn. Generally speaking, they're not sworn. So if you ever watch a courtroom proceeding, like in a period where they take a whole bunch of hearings in a day, let's suppose you go into court on a day with a bunch of drunk driving hearings where people are entering pleas of guilty or whatever it is, and you'll see an attorney walk up with his client, and the judge, if the person's putting in a plea, might say to the defendant, raise your right hand and be sworn. And they get sworn. But the attorney standing next to them does not get sworn. But the attorney will speak to the court the same way the defendant does. And some people will say, well, wait, why aren't the attorneys sworn? And it's because we are, in essence, sworn when we take the oath and we say that we will conduct ourselves in a certain manner. And everything we say in court is as if we are sworn. So we're actually held to a higher standard. Whether we're sworn or not, we're held to that standard. I'm talking about the actual physical raise your right hand and take an oath thing. So I've been in court countless times and said things to a judge knowing that if I said something false, I'd get in trouble for it, even though I hadn't been sworn. So that's what's going on here. The story's from the New Haven Register. Ben Lambert wrote it. Bob and AJ sent it. Thanks a lot, guys. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
Clouds come floating into my life, no longer to carry rain or usher storm, but to add color to my sunset sky.